today we're going to be talking about some really interesting cases that may impact any immigration filings that you have pending. So the reason why this is so important is because often that's how you gauge what the trends are. That's how you gauge how the USCIS is going to decide a particular case. So I thought it would be important, considering that people have adjustments pending, they have I-140s pending, that this would give them some insight onto how the case is going to be adjudicated. So for those of you who have been joining us every week, thank you for your support. For those of you who are new, welcome to our weekly webinar. We will have our Q&A at the end, and please put your questions in the Q&A box and not in the chat box. It just makes it easier to manage. And let's give it a few seconds for people to join and we will get started. And I hope you all have had a great week. Lovely weather we've been having. It's so nice to see the sun out and feel the warmth of the sun on your skin. It's great. And so let's go ahead and get started. You know, there are ways to connect with us on various venues. And remember, the reason why we're doing this is to make sure that you have the strategies, the tools that you need to make important immigration decisions. Immigration is a constantly changing landscape. So the only way you can make the critical decisions so you can achieve your immigration objective is to know what's going on, right? Knowledge is the best way to equip you to make intelligent decisions about your immigration future. So there are different ways in which we are able to impart this information to you: Facebook, Instagram, YouTube, LinkedIn, Telegram. So connect with us. We love hearing from you and hearing what your thoughts are. And we are always trying to put critical content on our YouTube webinars. So if you've missed one of our webinar series, we've got them now so that you can go to exactly the issue that you're looking for. We've got them indexed. So you'll be able to find the information that you need, but there's a lot of great information from there. And if you like any of the content, please, subscribe, because every time we upload something, the only way you'll know that we've got a new webinar going is if you subscribe, and then you'll be notified. And last but not least, if you like it, if something is helpful, please comment. I know several of you have, and I really appreciate that. And share it with your friends. That would be a way in which we can make sure more people have this immigration information. So the overview of immigration appeals, just to give you an idea of what it's called, there are two ways. One is we're going to talk about the PERM appeals, and then for USCIS appeals, it's the Administrative Appeals Unit, Office, AAO. So from 2017 to 2020, 2020 there were 65 cases that were dismissed, 15 that were remanded, which means they sent them back to the office below, and 18 that have been sustained, which is really interesting. And that's for the I-140 C, which is, I think, advanced degree. And then for D, there were 41 that were dismissed, 20 that were sustained, and 25 that were remanded. And that is a far cry from, in 2017, there were 104 that were dismissed, 37 that were sustained, and 22 that were remanded. So that's just an interesting outlook on how they're adjudicating I-140s. So immigration, DOL is responsible for the labor certification. So that is under a separate body, labor. And when a PERM gets appealed, remember initially sometimes they give you an audit, and then, if you are able to respond to that, then they either approve or deny it, or a notice of intent to revoke. And then you can appeal it. And, you appeal it to BALCA, the Board of Alien Labor Certification Appeals. And that gives us some insight as to how they're looking at PERMs. Because, with all, immigration cases, it's not just what's in the regulations, what's new in the regulations. There are people that are actually reviewing these applications. So the only way that you know what the trend is with the folks that are currently reviewing the applications is if you look at how they're deciding their cases right now. Now, some of the immigration matters can be, appealed to the Office of Administrative Law Judges. Administrative Review Board can hear appeals, and Board of Labor Certification is BALCA. But most significantly, it's the Administrative Appeals Office that reviews all USCIS decisions. And they issue either precedent decisions, that means decisions that they will incorporate as policy guidance, or non-precedent, which means they're not going to give it the level of a precedent decision, but they are important nevertheless to, look at how the trend is. Oops. So the standard of proof. The standard of proof, and this is really important because, if you've been keeping up with all the trials that are happening on the news, or you watch TV, lawyer shows, it's often easy to get misguided as to what standards are. Standards means this is how the person that is reviewing it should adjudicate it. So for these are all civil matters, right? But I know that you've heard for criminal matters that beyond a reasonable doubt, right? That means that there can't be any scintilla, any instance of doubt as to whether this person has done what is purported. That's in the criminal realm. Now, in the civil realm, there is something called the preponderance of evidence. That means that looking at the evidence, that there's a greater than 50% chance that the claim is true. More likely than not, right? More likely than not. That doesn't mean that it's beyond a reasonable doubt. That doesn't mean that it's, clear and convincing, which is a higher standard. It means that it is, if you're looking at the evidence, most likely it is true. When AAO looks at a case, they look at it de novo. That means anew. They try not to be curtailed or be blinded by the decision that was made before. They try to look at it de novo. And you've got to be able to appeal within a certain statutory period. And you use the form I-29B to do that. You can use the I-29B for a motion to reopen, motion to reconsider, or an appeal. Either or all of the above. Now, here's some main cases that are affecting I-140 adjudications. Now, this preschool was trying to hire or employ this person in an EB2 category as a curriculum specialist. So they initially approved the petition and then subsequently revoked it. So when they were reviewing the I-140, they said, number one, they didn't think the job required an advanced degree. And there was a lot of inconsistencies that they come up with. Now, in this instance, what happened was the labor certification said that this person was coming into work as a curriculum specialist. On their website, it stated that this person was a teacher. When the California Board of Education came in to do some inspection, they also presented her as a teacher. And when they did the site visit, they found the same thing. So what happens is there is an issue of, did you make a misrepresentation on the PERM labor certification? And one of the things they look to is inconsistencies. I always tell people that you've got to be really clear when you're preparing your PERM to make sure that whatever you're stating your experience is, that it matches with whatever evidence you're going to submit later on for the I-140. And then you always have folks who sometimes they'll call their job title one thing, and then when they get the experience letter, it's called something totally different. Or they'll have some of the dates mixed up. These may seem very small, de minimis mistakes to you, but what that does is that raises a doubt in whether the information you provided is correct. It may not rise to the level of willful misrepresentation, I'll talk about that, but nevertheless, it creates a form of doubt, which is going to make the USCIS go into further inquiry. And so when the USCIS, like I said, they looked into it and they found all these misrepresentations. Like for this fact, on the website, they had her presented as a teacher. And when they did the site visit, they had her presented as a teacher. So the director discussed that, okay, why is it that you've got these discrepancies? Give us some evidence to kind of overcome that. So the petitioner started giving some excuses like, okay, we had to do this because we were trying to get a grant. That's why we classified her as a teacher. That when the California Department of Education came in, that there was no other teacher that day, so we presented her as a teacher. But they said that they still were not able to, they didn't give any evidence as to why there was a misrepresentation on the website. And so they found that it didn't rise to the level of being willful, but nevertheless, it raised some concerns as to the validity of the PERM, hence the I-140. Now, in this particular appeals case, the petitioner sought to employ a machinist under the EB3 category that was originally granted and then revoked. And so the petitioner didn't demonstrate that the beneficiary had minimum experience for the job. And this was this foreign national was Polish, and there was some inconsistencies with the experience that they listed on the PERM application. Now, the beneficiary proffered, they said, you know, we don't have a letter of experience, but we can give you some sort of certificate that stated that, you know, we worked there. So the USCIS office in Poland contacted that employer and they said, we don't give certificates like that. This person never worked with us. And then the individual presented another employer that purportedly signed a new letter. And it was, you know, just really not clear that the individual really had that experience that they were stating. And so therefore, they didn't think it rose to the level of misrepresentation, but nevertheless, it was revoked. So misrepresentations are willful if they're, you know, it has to be a willful misrepresentation. It can't be, okay, I misrepresented something because I was mixed up, or it has to be willful. What does willful mean? That means you deliberately made that misrepresentation in order to secure that immigration benefit. You knowingly and deliberately made a false statement. And so if you are found to have committed fraud or willful misrepresentation, that is a bar for reentry into the United States. It's pretty serious. And remember, when you're signing the PERM, the beneficiary and the employer are signing it under penalty of perjury. So there is some legal effect to that, and you've got to make sure that you are pretty clear on what it is you're stating. Oops. So here, the petitioners seek to employ an industrial sales engineer, and they stated that they initially granted, then revoked. Again, there were inconsistent notes on employment, and the director thought that maybe there was some familial relationship. I mean, they thought that the consistencies were brought about because there was some relationship between the employer and the beneficiary because they worked in the same field. And so that was one of the issues. Another one was ability to pay was a concern that they had. And the employer said, well, just presented a letter stating that he had 100 employees or more. But on all the other documentation, it didn't show that he had 100 employees. And he said, well, no, my wife and I own two separate companies, but it's a family company. And so, as a result, there are more than 100 employees. And the USCIS was not convinced. They said they're two separate entities. Each entity has to show ability to pay. And so what they would look at is tax returns and so forth. So they had an issue with ability to pay, and the beneficiary was actually doing work, similar work as the petitioner. And so he was in a business relationship with them. So that was a concern. And remember, ability to pay, you can show ability to pay by either you've been paying the beneficiary as a W-2 employee, or the net income of your tax returns are greater than the proffered wage, or your net current assets are greater than the proffered wage from the priority date up till the date of filing the I-140. And by regulation, you're supposed to show that you can have the ability to pay through the permanent residence. But for just practical purposes, it's when you file the I-140. So here, number one, they thought that it really wasn't a bona fide job offer because the individuals had been working together in a previous company. And then they couldn't show the proffered wage for the entire period. And what happened was that the employer then said, well, I have a lot of 1099s. I paid the employer's company, because remember, they had that business relationship, as a 1099. And they said, no, you've got to show them W-2s. And so they could not show ability to pay. And they were not able to really even show that there was a bona fide job offer. And there were inconsistencies with showing that the beneficiary actually had that experience previously. So that's why it's really important to make sure that your inconsistencies are guarded and that you're able to really clearly show that you have that ability to pay. So in this particular instance, remember how the I-140, if there's any issue with the I-140, you have a 45 attached to that. If the I-140 is denied, so is the I-485. So here are some cases where that had took place, where it was the ability to pay. It was the issue of whether the employer actually, had the requisite background and knowledge to intend to employ the and whether the individual had the qualifying experience. Again, it comes down to the misrepresentation. And why is there a misrepresentation? There's a misrepresentation when there are inconsistencies in the record. Like I said, what you put down on your PERM is really important, and you should remain consistent throughout. Otherwise, it's going to cast some doubt onto whether, it is actually a bona fide offer of employment or not. And that's when they start doing additional assessments. Here, the problem was that it was an IT business seeking to employ a programmer analyst. And they filed the appeal 6 years and so it was rejected because it was untimely. Remember, you have the 30 to 33 days. So if it's come in mail, then you've got 33 days from the date of the decision. And so you've got to be really, you either use it or lose it, as they would say. So in this instance, this is a dry cleaning business that seek to employ a tailor, an alterations tailor under EB3 skilled workers. So the individual actually came in as a, E2. They had been doing some, remember, E2s cannot become permanent residents on their own. So what happened was that they also noted that the petitioner somehow filed a petition on behalf of the beneficiary's daughter, which they thought was real. Because if you have any familiar relationship, if you're related to the person that's filing your labor certification, you have to make an indication and show otherwise. So they didn't, and they couldn't understand why, if they didn't, why did they file a petition for the beneficiary? And they had stated no. And then there were also questions about the ability to pay. So instead of outwardly revoking this, they remanded this, directing the DOL to, request information about the employment history and the ability to pay the proffered wage, and review it again with the facts that were presented, which is very uncommon. Usually, like I said, we've seen how many remands that there are, in so much as compared to how many cases are dismissed. In this particular instance, the employer wanted to employ a physical therapist, and there was issue of ability to pay. When they did a search, they found that the business was dissolved, and they couldn't establish ability to pay. And so then the beneficiary said, well, hey, there's another petitioner that's willing to file for me. Can I go ahead and port and change positions? But the problem is, you can only port when AC-21 works. If you guys have been listening to me, you know this. AC-21 portability needs 3 things: an approved I-140, an I-485 that's been pending for 180 days, and same or similar employment. So the USCIS said, the AOA, the appeals unit said, wait a minute, your I-140 is not approved, so you can't port. And this particular employer has not been able to demonstrate ability to pay. So it is dismissed. And this is one where a convenience store owner, we had talked about this early on the I-140 realm, but it was also, it impacted their 485 because when, like I said, when you're disclosing, if you've got a personal or prior relationship, you have to show that. And then you also have to show your intention to work for the employer. So some of the things that they had stated was they thought, there may be a relationship between the beneficiary and the petitioner, which in and of itself is not a bar. But, you have to make sure that there still is a bona fide job opportunity. So the labor certification was for Virginia, and the beneficiary was working in Texas. So they said, the USCIS denied it, saying, well, you're not even living in Texas. How do we know that you're going to work there? Well, that's not the standard. This is for future proffered employment, right? So the beneficiary did accept the job offer, and they showed that the beneficiary on her I-485 had a Virginia address. And so it not only demonstrated that she was willing to go to Virginia, but she had already moved to Virginia. So then the only issue was ability to pay. So they remanded the decision back to the USCIS to re-adjudicate the ability to pay. PERM cases. And we'll go through these pretty quickly so we can get to the Q&A. The referral program has been fraught. If you remember, for PERM, you have to show that, number one, that you've placed an ad in, the newspaper. But if you're a professional, you have to show a number of other recruitment methods, one of which is the own employer's or petitioner's employee referral program. Now that's gone through kind of a great transition. Initially, it was only enough that the employer had an employee referral program. But then they wanted to make sure that, is there a benefit that's outlined in the employee referral program? So it's not enough to have just an employee referral program, but the employee referral program has to show that anybody that uses the employee referral program will maybe get $100 or something that allows that. And you have to make sure that all jobs, including the job offered, is covered, to make sure that you're actively promoting that particular job opportunity. And you have to make sure, like I said, the incentives are clearly outlined in whatever documentation. Most people, it's the employee handbook, but if it's on the employer's intranet or someplace, it's got to be clearly stated so that the employees can see that, and the benefit has got to be clearly outlined. And you have to show when it was posted. You can't just put it up just for the PERM. You've got to show that it was actually in existence at the time. And so these are some of the things that they look at when they're assessing an employer referral program. Now, the employer also has to post what's called a notice of filing. So what you're doing is you're posting a notice of filing for a specific period, which is a little different than what you do for the H-1B. And in this notice of filing, what they look for is they're telling anyone, hey, we're getting ready to hire a permanent position for whatever the position is for this many wages. If anyone has any complaints or issues with regard to this recruitment, please make sure that you inform the director of, it's got the DOL address, the certifying officer DOL. And so in this particular case in Alcoa, they had listed the State Workforce Authority, which, you could say it's and or, but there was it basically rendered some confusion and could deem that it was defective. Now in Google, this is a good illustration of why employers should be careful to be consistent with the description of the job requirements and the advertising. Because here there was some inconsistencies with the way the job was advertised and, you know, how it was outlined. And in the Eaton Corp, you know, I always tell employers, it's really important. We usually provide guidelines. You should contact, when you go through the recruitment process, you should contact the people timely. You've got to demonstrate that you, and I usually do this by a read receipt, you know, back in the day, before the internet was, you know, yes, I'm a dinosaur, was that we have the employer send out certified letters to the prospective applicants. But here you can send a read receipt and to confirm that, you know, it was delivered to whatever address you had, and you tried to recruit them. And the issue is that through this recruitment, you only have to recruit, or you only have to interview those applicants where from the face of the resume can seem that they are qualified for the job. But DOL has often said that they don't list all the requirements, and therefore, in abundance of care, you should make sure that you try to reach out to, you know, to find out whether the individual has this requirement. They just didn't list it on their resume. So it's really important that you go through that process and go through it critically. So I know that we went through this fast. I know that you all have a lot of questions, but I wanted to make sure that you saw kind of the trends. These are all very recent cases. So what are some key takeaways? Key takeaways are, make sure that, you know, you address any discrepancies that may be in your PERM application versus your I-140, and you do it proactively. I mean, I would go back even further. If you haven't filed a PERM, make sure that what you outline in your PERM form can mimic the experience letters that you have. We don't even like to file until we have the experience letters, because we've seen so many problems can come about as a result. But that's really critical to review. And ability to pay. I've been telling people that since last September, when we were getting ready to file all those downgrade petitions, that ability to pay, you know, you've got to do that analysis beforehand. And if there are multiple I-140 petitions the employer is filing, you have to be able to do that for all of them. And if you've already got that argument in place, even if the USCIS issues an RFE, you're ready to respond to it rather than playing catch up and trying to connect the dots afterwards. And I have always said this, that you've got to have a bona fide current intent to join the employer at a later date. And I had suggested to a lot of you, make sure you have that in writing. Because these are all, if you see this, are the key issues that come up, wanting to make sure that there's no misrepresentation, that there's a bona fide job offer, and the employer has the ability to pay. So if you haven't joined us on our forum, please join us on our Cella chat forums. Let me just take a look. How many of you are joining us for the very first time? Raise your hand. So as people are raising their hands, great, welcome. How many of you have learned about our webinar because you're on our Telegram forum? Raise your hand. Fantastic. And then, thank you so much. And I've just launched a poll. It's an anonymous poll. I would love it, as we're doing the Q&A, if you all could answer the poll. That would be very helpful. But if you all haven't, if there are a number of you that have not joined our Cella chat forum I would encourage you to do that. It's a great community. I mean, I love to see other, folks helping each other out, giving one another support. Like I said, that's what we're trying to build. We're trying to build an immigration community where we all can work together to achieve the immigration success for everyone. And as we stated, you can connect with us in a number of different ways. Check out our previous video recordings. And if you don't get a chance to ask a question today or think of something later, email us at info@cellolaw.com. And like I said, subscribe to our YouTube channel so you know that when we put out fresh content, as I've been saying, this is going to be a very, not volatile year, but a good year for changing the immigration landscape. So it's really important that if you want to learn about those changes, that you stay connected with us. And pursuing permanent resident strategies for pending and future green card applicants. And next week we're going to be talking about some family immigration. We'll still do Q&A and any updates that have come up on the immigration realm. And we will also, the week after that, it's going to be H-1B RFEs. So if you've got friends that may be impacted by either one of those issues, please have them join our webinar. And if there's any topics you'd like us to cover, please email us at info@cellolaw.com. And so I'm going to invite Shaker Chella to join us so we can go ahead and get started with our Q&A. Hi, Shaker.
Hello, Lakshmi. How are you?
Good, good.
Looking good?
Thank you. I had to change venues because they're doing some work in the kitchen today, or near the kitchen.
Yeah. Okay. Good afternoon, everybody. I hope you're doing well on a Wednesday afternoon. So let's get going with what we have today on the agenda, on the plate for Q&A. First question from an anonymous attendee. With current speed, it's almost certain that USCIS is going to waste lots of visa. Have you any insight how Biden administration is trying to use all spillovers this year?
Yeah, they are trying to make sure they add additional resources. No one wants to waste the additional visas. And we have, you can, I don't know if we've posted it or not we have Oppenheim's latest information on what his predictions are for the visa bulletin. Team, can you let us know whether we've posted that or give folks the link that they could get that? You can email us at info@cellolaw.com. If you haven't joined our Telegram group, we're going to be posting that to our Telegram group today to give them the latest information. So if you want to get this information about the current predictions of the visa bulletin from the guy who makes those decisions himself, then join the Telegram group.
All right. Next one is from Satish Rayala, sorry. I think a new person, welcome. I have completed 4 years bachelor's degree in computers in US, and currently I'm using 3 years STEM OPT, and I'm working now. I have one more chance to apply for the H-1B in 2022. If I don't get picked H-1 next year, can I do master's and get 3 more years OPT? If I do master's while studying master's, can I be eligible to apply for H-1B?
Yes, that's exactly what you can do. You're one of the few that it's hard when you come here for a master's and then the only upper degree then becomes a PhD, but because you're doing a bachelor's, as long as you go into a higher academic degree program, you can get a new fresh 3 years for your OPT.
All right, Satish. Love to know where you're doing your bachelor's in computers, which university. By the way, whenever your attorney asks a question or clarification, just put it on the chat. So it's easy for me to look at it and, relay back to her. Don't put it in the Q&A. Please put your questions in the Q&A.
And I know Max said that we're still finalizing the editing, but I'm going to be publishing that in Telegram. So if you want to get it, you're going to have to, sorry, Mac, not at info. They're going to have to join the Telegram group to get the insights.
Okay. Next one is from an AA. Had a question. I heard from someone that as part of the Dreamers Act, those who migrated to the US prior to the age of 21 can apply for a conditional green card. The condition is then said to be removed after attaining a bachelor's degree of some sort. Is that true? I have been in the US since I was 12 years old, then graduated high school and college STEM degree, and now I'm a consultant at PwC. I want to know if I will be benefited from this.
Right. So that is still in flux. There's a couple of different bills out there for Dreamers, so it just depends on what is finally picked up, whether they're going to merge a couple of the requirements or whether they're going to just go with the one. So we have to kind of wait and see how that plays out. But I guess I'm going to assume, did you apply for DACA?
Don't say that. Don't think it says that.
Okay, great.
So maybe you'll, any answers, I'll pick it up. Let's go to the next question. Anonymous attendee, after traveling on advance parole, should one file back H-1B to gain H-1B status from parole status in case I-140 is pending?
No, remember that you can travel on AP, you can travel on your H-1B, as long as you don't work for an employer other than your H-1B employer on your EAD, you're still in H-1B status, so you don't need to amend.
Okay. Next one is Karthik Rajashekaran. IMP may be important. I will be completing 180 days of 485 on April 27th and still not got EAD. Will be joining new employer on May 10th on H1 transfer. Will it be any problem for EAD or H1 transfer or GC?
As long as your I-140 is approved, you already said your 485 has been pending for 180 days, and you are working in same or similar, then there's no problem.
All right. Next one is from an AA. I have a question about I-140s and subsequent job changes. I am an Indian citizen born in India with an I-140 filed and approved from a previous employer, in parentheses, approved more than a year before changing jobs. I have changed my jobs, so does my new employer have to file a new GC petition from scratch, including the LCA stage? If so, is there a time limit within which that has to be started through the new employer? Thank you.
Okay, if you didn't file a 45 with your previous I-140, the good news is you get the priority date, and the priority date ports with you. Bad news is yes, you do have to go through the process over again. But there is no time frame. They can start immediately. There's no time frame that they have to wait to get started. And so I would do that as soon as possible, because the prevailing wage may take some time. And we've had, I think we did a webinar on what you need to look at for your PERM if you're filing a PERM, and I hope my team can send up that link for that webinar. Take a look at it so that you don't run into some of the problems that we discussed earlier today. And guys, don't forget to answer the poll for me, please. Thank you.
All right, next one is another AA. Just want to know what card, PIO or OCI, to be applied for my mom, who just became US citizen from India. Thank you.
There are vastly different distinctions between the two. I found that the OCI is probably a better mechanism to travel and, you know, keep going back and forth. So, and I think we had written something about the differences between the two a long time ago. But what I'll do is that this gives me a good opportunity to get a topic to write an article about PIO versus OCI. And so I'll make sure that we do that. And if you can email us, I'll make sure that you get a copy of that copy of that memo when we do.
Okay. I think that gentleman or whoever was asking, you asked if he applied for DACA, he answered in the Q&A. Haven't applied yet on TN visa.
Yeah, so
The consultant for the PwC.
we'll have to just wait and see what, you know, there's a lot that happens when you have multiple bills for one particular initiative, if you will. There's reconciliation. They try to reconcile the disparities of the bill and the various provisions. So it's hard to kind of predict what through reconciliation will remain. But if you are connected to us on any of our social media, as soon as we hear anything, we'll let you know.
Okay. So once again, please answer any follow-up question your attorney is asking in the chat, please. All right. Lipi Mohanty. I'm currently not working for the employer who had filed my GC. However, he supported me when I was filing for my 485. My biometrics is done. Do you still think I need to worry about the bona fide part?
Well, you know, like I said, you have to have, at the time you filed, you have to have the present intent to work for your previous employer. And if you remember, Lippy, back in October and November, I kept saying, make sure there's an email, something to show that you intend to work for that employer, and it was not just concocted for the sake of permanent residence. That doesn't mean you have to, but you have to have the intent to, because what you don't want is you don't want the USCIS to question the bona fides. And if you're not working for that employer now, you know, they could question it. But if they question it and you're able to say, well, here's an email where we discussed that I would join them after, you know, the GC is approved, you know, that would reconcile that issue.
Okay. Anonymous attendee, any latest updates on asylum?
Not yet. I know that a lot of people weren't pleased that Biden has not currently, at least, increased the number of, you know, asylees that he's going to accept. But I think it's just because, number one, we're still dealing with this pandemic, and number two, you know, still dealing with limited services because of the pandemic. One of the things I did want to bring up, I know that we posted it on some of our sites, that there may be, UK has already instituted a travel ban to and from India, and the US may be instituting one because the insurgence of COVID cases in that country. So that's just something to look out for.
All right, next one is from AA. As you mentioned about Charlie's visa bulletin, but Charlie mentioned in his chat that he's not aware how USCIS is planning to use all spillovers. As you work with Biden administration, can you suggest them how to use visa number faster?
No, that's a good point. I mean, one thing we don't want is for people who have been waiting in this queue for 12 years, and now just because of lack of resources, those numbers get wasted. So that is something I'll make sure to, I'm putting an agenda together for the API group, and that's one of the considerations I'll make sure we mention. I'm fighting for you, believe it or not, whether I tell you all the ways in which we are doing that, but rest assured that I'm fighting your fight.
I think Lipi Mahanti follow-up said, the answers to the above question is yes, then what should I do and how can we be prepared for that? I think you probably answered. But
yeah, Lippy, if you've got emails from before where you told your employer that you're planning to join him once your green card's approved or anything of that nature, then that would suffice. Maybe talking to them even now through email about, okay, it's currently taking this long. It may be X amount of time before I get my green card. How do you want to discuss the transition? Not that you have to, but at least, if you've, like I said, you have to have the bona fide present intent at the time of filing to change employers. AC 21 allows you to change your mind later, but you just want to make sure that you have that information readily available.
all right. Next one is from AA. Thanks for your time. As part of EB2 to EB3 downgrade, biometrics are completed a week ago. Filing date October 25th, 2020. By what time can I expect the EAD in hand? And by what time can I expect the I-140 downgrade approval?
Well, since you filed in October, you should try filing for premium processing. We've said that in some of our previous webinars. For most people who filed at that date, the DOL has already received the PERM. Remember, that's why you couldn't file premium in October, because we had to wait for DOL to get the PERM. Well, DOL may already have the PERM. So you can try filing your, upgrading your I-140 to premium. Worst comes to worst, they'll return your fees if they don't have the DOL. Secondly, I don't know whether, I can't really predict because it's kind of erratic from the biometrics time when people are actually getting their EAD. I think my team may be able to outline what the general time frame is, but I wouldn't take that to heart because I've seen some people get it earlier, some people get it later.
All right. Another AA, what is the maximum time limit an employee can be on FMLA on H-1B? My company says 12 weeks. Is it true? Do we need to notify USCIS about this leave?
Yeah, it should be the company policy on the Family Medical Leave Act. What the rule is whatever they're applying to their H-1B employees, it's got to be the same thing they're applying to all their employees. So it's got to be written in some sort of document. Most of the time it's in the handbook as to what their Family Medical Leave Act policy is. If there's an intranet, that means an internal communications platform that your company has, they may have it on there, but it should be on something that's readily available for most people to review.
All right. Another AA question. If you travel on AP and return to US using the AP, can you continue working on your H-1B? Do you need H-1B stamping in order to continue working in H-1B?
No, H-1B and L are dual intent. You can intend to reside here temporarily, and you can intend to reside here permanently. So that means that you don't need, you can, as long as you are working for your H-1B employer, i.e. you're not using your EAD to work for somebody other than your H-1B employer, you can enter on your H-1B visa or you can enter on the AP, does not make a difference.
All right. Next one is from Sri Kumar. My spouse's H-4 EAD expires by end of June 2021, and she can't work after that. I'm counting on her GC EAD to be approved before that. Can we expedite my spouse's derivative GC EAD stating financial loss?
You can, we had a webinar a couple of weeks ago where we talked about how to contact the USCIS and request an expedite. My folks will post that up. So take a look at that because that has the phone numbers, it has the process, the procedures, the whole 9 yards.
All right, an anonymous attendee, next one. My I-485 GC date is current and it's been 2 months. I didn't receive it yet. My filing date is December 2009. How long it will take? And can I travel out of country while I'm waiting for my GC?
You know, you can, what will happen is if it's, you may get, we don't know that there's not been an official notification that interviews are waived. So you may get an interview, but, and that if you postpone it because of the limited services, that could delay it. But there's nothing precluding you from traveling while you're waiting.
All right. Another AA. Please let me know if your law firm helps with opening LLC Inc.
Sure. Send us an email.
Yeah, just send us an email and with all the information, we're glad to help. It's, I think, almost close to 1, so we'll just figure I got another 5, 6 questions. So we'll stop after this, or you have extra time?
No, I mean, 1 o'clock. And I want to tell folks that if you know any E3s, tomorrow at 12 o'clock Eastern Standard Time, we're having an E3 webinar, not only to help, well, and other people who are not on E3, it could be helpful for them because we're going to go over the permanent residence process. I think somebody on this webinar today said that they're going through the PERM process, so that could be of help to them. But it is tomorrow at 12 o'clock Eastern Standard Time.
All right. So, ladies and gentlemen, I've got questions already, which take us through the end of today's time. So, if you didn't get a chance to ask, please do send an email to info@chalalaw.com. Be glad to help. Glad to send you a response very soon. Let's go to the next one. Another AA. My company lawyer made a typo in my joining date, current company, in my PERM application by 2 days. Will this have any impact on my 485 application? I also noticed that they also use the same date on my 485J application. Will this impact my I-485 approval? Do I need to take any action on this?
Well, without looking at all the facts of your case, I wouldn't know whether you should do it proactively or not. But if you know that your the attorney made a typo, I hope you have that communication by email. Because if the USCIS does raise a question, you can at least use that to respond to the inconsistencies, any inconsistencies that may have been brought about by the record.
All right. Libby Mahanti says, thank you for answering my question. You're welcome. Sri Kumar is back. We gave we gave my biometrics 2 weeks back. When can we expect EAD AP combo cards?
As I said earlier, you can't really predict. Some are coming sooner, some are coming later.
And he's got another question. When we expedite our GC EAD, and if it gets accepted and approved, will USCIS also approve 131 and issue the EAD AP combo card, or should we specifically mention to approve I-31, 131 also?
It is, I mean, I think that they would approve both because it's only one card that they would issue, but maybe you want to ask for both when you're making the request. So there's no ambiguity.
All right, last question from AA. By when can I switch to a new employer after getting EAD and 140 downgrade approved from current employer?
In order to port using AC-21, I-140's got to be approved. I-485 has got to be pending for 180 days, and you've got to work for same or similar employment.
That's it. Thank you.
Thank you, Shaker, and thank all of you for joining us today. Thank you for participating in the poll. And I look forward to seeing you next week, where we'll give you some additional updates on what's happening with immigration. Let us know if there's a particular topic you'd like us to cover at info@cellolaw.com. And if you haven't joined our Telegram, do because we're going to be posting some of these updates on that group today. So have a safe week. Thank my team, Kara, Mac, and the entire group for all their support in putting this together. And if you have anybody that's interested in either the PERM process or E3 issues, have them join us tomorrow, same time, same channel. That's what Batman used to say, same time, same channel back in the day. So, so join us tomorrow for our E3 webinar. And thank you, Shaker, for taking time out to moderate as usual.
Thank you. And as
Great job.
our TV anchor man, Ron Burgundy says, stay classy.
Stay classy. That's right. That's Ron Burgundy. Really important to imbibe him today. So take care. Bye-bye.
All right. Something to look forward to.
Yes. Bye-bye.
Right. Bye.